Good morning, Ms. Fallon. Good morning, Mr. Graham.
Good morning, Your Honor. And may it please the court, I am Stuart Graham, counsel for the defendant, Jesus Gambora. We briefed 5 issues in the brief. I hope to address at least 3 of those today. It may be optimistic. But Mr. Gambora was convicted of deliberate premeditated murder and felony murder, as well as some related offenses, all coming out of a robbery of a motel in West Springfield, Massachusetts. There was a latent fingerprint found at the scene, which the Commonwealth's expert at trial declared was a match to Mr. Gambora.
Experts? Were there 2 experts?
I believe so.
Two separate fingerprint experts. 2 separate fingerprint experts on the same fingerprints?
I think so. Yes, Your Honor.
And did the defense have an expert as well?
No, he did not.
Did the defense seek funds for a fingerprint expert to do its own evaluation?
I don't believe so.
Okay. I did see a number of expert funds requests in the docket, and I was just wondering whether that was one of them.
Counsel had filed a motion in limine prior to trial to prevent the introduction of both fingerprint identification pursuant to the ACEV method and in testimony of individualization of the print. That motion in limine was denied. It was renewed at trial
on
again
the
overruled.
basis that it was scientifically, it didn't satisfy Daubert, or was that the basis of it?
No, the basis of the overruling was this court's decision in Commonwealth v. Patterson.
No, I'm sorry, I wasn't clear. That was the basis of the motion.
Yes. He did not, if I think you're understanding it correctly, he did not challenge the particular way in which it was done in this case.
Right, just the method,
It was
the whole
challenged
method.
generally
yes.
ACEV
So-
and individualization.
Then it would be consistent that he wouldn't seek funds for an expert.
That's correct.
Yeah.
Unless, okay. So he's not challenging the application.
That's correct.
So he's not.
Challenging the discipline,
Okay.
and
Indeed, he doesn't even contest that they were not his fingerprints.
that's correct. To the extent that he is not contesting that the application of the ACEV method was flawed in some way. He is contesting, and did contest, that an expert can declare a match between a particular latent print and an ink print. To that extent, he is contesting the reliability of the fingerprint identification. The trial court obviously was bound by this court's decision in Commonwealth v. Patterson, so it could do nothing but deny the motion to eliminate and overrule the objection. Patterson relied upon the Frye standard of general acceptance in the relevant community for admissibility. Mr. Gambora would assert that using the Frye standard when the discipline of the relevant community is being challenged essentially begs the question. I think as the Supreme Court in Kumho-Tyre v. Carmichael indicated, it's like concluding that astrology is a valid method because the community of astrologers accept it as a valid method.
I guess I didn't read Patterson as quite so wedded to Frye, although there certainly is language about looking at the relevant community. I would agree with you. But let me ask you this. Assuming all that is so, your client testified that he put his hand on that very, I forget what, doorknob, or isn't that right? So
That's correct.
how do you deal with that?
In both the main brief and our reply brief, we noted that his testimony, his taking the stand and testimony regarding his presence at the scene was impelled by what we believe was inadmissible fingerprint evidence. That is, he had to some way get on the stand and respond to evidence which came in the guise of objective evidence, placing him at the scene. As we put in the reply brief, that neither waives his objection nor makes it harmless, because he had to do something. It's a variant of the doctrine of curative admissibility. And so that objection is still valid. The fact that he testified neither waives it or renders it harmless. Since the National Academy of Sciences report has come out, subsequent to Patterson and subsequent to the trial in this case, it has challenged and pretty much established that the ACEV method, and particularly individualization, has not been scientifically validated. There is not sufficient science to say that it is reliable, particularly as regards individualization. The court cited approvingly to the study by Haber and Haber, which said, and I'll quote, "We've reviewed available scientific evidence of the validity of the ACEV method and found none." The court concluded, citing Professor Moonkin, that given that there is no validity testing, no statistically valid model of fingerprinting, no validated standards for establishing a match, that testimony as to individualization should not be allowed. Now,
They're just citing other authors who have so
yes,
concluded.
approvingly.
Approvingly. They've
yes.
cited other authors.
That's correct. It's part of the evidence they gathered for their conclusion as to the present scientific validation.
Is scientific validity the only method by which evidence can be viewed as sufficiently reliable to be presented to a jury?
I think, Your Honor, when we're dealing with what purports to be scientific evidence, then yes, there has to be some degree, sufficient degree of scientific validation.
Well, how do you scientific, I mean, there are studies about error rates, and the error rates, even in the studies that are referenced here, demonstrate the error rates are very low.
But not non-existent.
Well, okay. Isn't that the subject of cross-examination?
Well, that's the claim of the community, is that the error rate is non-existent. But there have been...
And the study says, well, they should be a little more humble about that. Come on.
Quite a bit more humble.
Yeah, because the application can be quite varied, depending on the expertise of the examiner, the quality of the latent print. All of these variables make the notion that you can definitely, positively, beyond doubt, compare or individualize such a latent print versus a regular print to be perhaps overstated. But does that mean it's not relevant or admissible or reliable in any ordinary sense?
Two points. We're not claiming here that fingerprint evidence should never be admitted. What we're claiming, two things. First, that testimony that a latent print can be certainly matched with a particular ink print has no scientific validity at this point. That testimony should not be allowed. That's the major error in this case. Secondly, we're saying that a Daubert hearing should be held on remand, where the lower court is bound neither by the Frye standard nor by this court's decision in Patterson, so that a determination can be made as to the best way of proceeding to present fingerprint evidence, whether it should be admitted or not. But what's the best way of doing it? Is there a statistically based model for doing it? I would note that the report found, and I think this court would agree, that DNA evidence is perhaps the most rigorously scientific trace evidence that we have. And even there, the courts require it to be expressed in statistical terms. But with fingerprint evidence, which actually has no empirical validation, we allow it to come in with certainty.
When you say no empirical validation, what do you mean by that?
What I mean is two things. First, well, let me rephrase that. Uniqueness and persistence, as this court noted in Patterson, as the report noted, are necessary conditions for fingerprint identification. However...
And there's no challenge to uniqueness in this study, by the way.
No,
the study doesn't say, well, the claim of uniqueness is not valid.
No. Uniqueness, in fact, is a necessary condition.
Okay.
And
there's no challenge to that.
There's no challenge to that. The challenge is that there's no scientific validation that any analyst can reliably distinguish between otherwise unique prints.
Well, how about why aren't error studies relevant on that subject?
There have been no, according to the report, no good error studies conducted. The community of fingerprint examiners declares that there are no errors.
Well, but there have been lots of error studies. You just don't like them.
Well, there have been lots of errors as well. And those errors eliminate the possibility of absolute certainty And that's the important point here.
How could there can never be absolute certainty when a technique requires a human examination and application of standards. There will always be individuals who are better or worse at that, and quality control standards, which will cause some evaluations to be in error, and that's what cross-examination is all about.
Well, that's precisely our point, and that's precisely the point of the study, that you can't state it with that kind of certainty, and therefore it's error for a fingerprint examiner to get on the stand and testify that there is that kind of certainty, and they can make a match of that kind of certainty. That is, we're not saying no fingerprint evidence should come in, but it shouldn't come in under the guise of absolute certainty when we know that the variables involved are such that that certainty cannot be determined. There has to be a way of expressing that degree of uncertainty which is inherent in what is otherwise a subjective method.
So you're saying if you go ahead, excuse me, Chief.
No.
Go ahead.
Let me ask you this. There's been no motion for a new trial here, correct?
That's correct.
And you don't have an ineffective assistance of counsel. I mean,
That's correct.
It's a direct. As I listen to your responses to Justice Cordy's question, it sounds to me you're asking for what is almost a bright line rule, and yet your responses suggest that this may be an appropriate case where you look to see why counsel didn't inquire. Now, counsel did or did not have the opportunity. What's the relationship between the date of the trial and the National Academy report?
The report came out probably a year or two after the trial in this case.
I mean, and the challenge for us is going to be, we have that report. Counsel are not going to have conducted the inquiry in light of that report, although, as you know, Judge Pollack in Philadelphia raised this issue very, head-on several years ago. I mean, it seems to me that to, go through all of the criminal trials that have been conducted that are on direct appellate review in the wake of the National Academy, we can't just keep sending every single one back again, correct? Because counsel didn't cross-examine in a particular kind of way. So you have to get me to a much closer error of law standard than I'm hearing from you at the moment.
The primary bright line rule that we would like the court to establish, at least one today, is that expert testimony of individualization should not be admitted.
You mean by that, this is a match?
That's correct. That should not be admitted. The science is pretty clear that the degree of reliability there is not such that should be admitted. Secondly,
should never be admitted.
That's correct. Not until at some point in the future where there is some validation that can be stated. But at this point, there is not. Secondly,
So what is the testimony? I'm pretty sure, based on all my experience, I am positive, quite sure, 99% sure.
Yes, that comes to my second point, Your Honor. What should be done is this case should be reversed and remanded to the trial court to hold a Daubert hearing that is not limited by either Patterson or the Frye standard, so that the court, now taking the NAS report and this court's guidance, can address this issue, establish the factual and evidentiary basis and scientific basis for an approach that's proper for fingerprint evidence. I would suggest that the procedural order issued by Judge Gertner in the federal district court here is pretty much along those same lines, as any case that's going to have trace evidence in her court now has to have a Daubert hearing to establish precisely the kinds of factors that the NAS report identified, to see how it is that fingerprint evidence should be expressed in court. That's something that must be, I think, determined after a full hearing, unrestricted by Patterson or Frye.
I don't understand why that isn't the subject of cross-examination, and perhaps very fertile cross-examination. You say this is absolutely, well, let me point you to this study and this other study, and you can't really say that, can you? I mean, why isn't the evidence reliable enough to get before the jury? And certainly this report doesn't say it can't get before a jury.
No, this report didn't deal with that issue. But as to two things. First, as to individualization, no, it's not reliable enough to go before a jury. That should not come in.
Let's assume that we don't go all the way with you, and essentially you are claiming that there was no Daubert hearing held, and it should have been held.
Well, not that it should have been. It would have been an empty ritual to have been held because this court has already determined in Patterson that it's admissible. The trial court could not have ruled otherwise.
I understand that.
That's why it was no
But
Daubert
Patterson
hearing.
predated the National Academy study.
That's correct.
And so I'm trying to figure out procedurally, if we were inclined to get some fleshing out of this, other than our recent go-around with Melendez-Diaz, when have we remanded for some proceeding, motion for a new trial, some further proceeding, when some scientific, this is not a new rule of, this is not a development of the law, which is you get all the benefit on direct appeal. Why would your defendant get the benefit on direct appeal of some development in the scientific community?
Because the rule of law that was established in Patterson that this evidence is admissible was based upon scientific evidence, which is now shown to be in doubt. I think it undermines the court's decision in Patterson.
I'm just trying to figure out what's the closest analogy. Get me there through some other time that we've done this. When DNA was new and in its infancy, correct? We did a number of things, but I don't think we ever. I can't remember if there was DNA evidence proffered, it was accepted, somebody was convicted, it came up here, and we sent it back in light of the then studies on DNA. I think it all got resolved in the first instance at the trial court.
I know in Lanigan this court, in fact, referenced the NAS report there.
Oh, no, we
reference
reference NSA reports.
I can't think of a particular case where this kind of issue has been raised.
Except that if in fact the defendant had hired an expert that came in and said, no, I've taken a look at this, at the exemplar, and I've taken a look at the defendant's actual print, and in my opinion, they are not the same person. That's got to have happened in hundreds of cases where there's been a divergence of opinion about precisely the same fingerprint when compared to the defendant's actual fingerprint. So isn't it inherent that there is a difference of opinion, or that this concept of, quote, match is susceptible to a difference of opinion?
It can be. In fact...
Isn't that the answer to your question?
No, the problem is the certainty with which the Commonwealth's expert opinion is clothed. It comes in as the Commonwealth's expert declaring absolute certainty.
Well, but a defendant could hire an expert and say exactly the same thing. That it's not. I am absolutely certain that this is not his fingerprint.
And neither.
Why doesn't it go to the weight of the expert's opinion?
Because it's misleading to the jury that either expert can state with absolute certainty in a close case that it's one way or another. That misleads the jury into a search for certainty that is not there. That's the problem.
But isn't it the sense that I have about fingerprints is that this whole concept of absolute certainty, which you don't dispute in this case, is that no two people in the world have the same fingerprint.
No, he does dispute that, don't you?
No, we agree that the evidence as such of uniqueness is probably correct, but there's no scientific validation that an expert can distinguish between two otherwise unique prints. That's the issue. And
that's because of human error, isn't it?
That's because
and that no person should be allowed to get on a witness stand and say that, in my opinion, it is absolutely certain that this is not the same or this is the same person.
I think you can say with certainty where there are absolutely no matches whatsoever that it's an exclusion. But you can't say with that kind of certainty that it's a match. That's misleading. That's not scientifically validated, and it's inherently prejudicial.
But isn't it really more of a matter of overstated confidence in the expert's opinion?
Well, it is overstated confidence, but that overstated confidence misleads the jury into a search for certainty that can't be achieved.
But it's a slightly different thing. It's saying that at the time that the expert evidence was given with confidence, and what were his exact words in this case?
He said it was a match to the defendant.
It
yes.
was a match,
Yes.
right? Prior to the National Academy study, there would be no reason why he could not have said that, correct?
That's correct.
And that's what experts said all the time, and it may well have been that a defense expert looking at the then, as it were, protocols of fingerprint identification might have agreed with the expert that if you have this number of matches, it is a match, correct? So that it's not two people looking at the same data and interpreting it differently. Two people using the then existing protocols would come to the same degree of certainty.
They may have.
They may have. Now the National Science Academy says you can't do that because if you have these kinds of however many matches it is, that is not sufficient to establish to a degree of certainty that this is a match.
That's correct, Your Honor.
But this is nothing new. This is not a new argument. In fact, in Patterson, there was an extensive Daubert hearing in which precisely this testimony and other testimony was presented.
But it was rejected.
That's right. This court rejected all of that and established a rule which bound the lower court in this case. The National Academy of Sciences.
No. What I'm saying is the trial judge concluded that in spite of the fact that there were studies and individuals who contested the ability to be certain, the then prevailing methodology, which remains the prevailing methodology, was generally reliable and therefore was admissible. So there's nothing new, really, there's nothing new in this, except this is a compilation of studies of people who disagree as to how certain one can be.
Well, I think that's sort of a mischaracterization. It's not just a compilation of disagreement. It's a scientific examination of forensic evidence by independent scientists who are examining the state of forensic evidence in the United States and came to the conclusion, based upon all the science available, that fingerprint evidence is just not sufficiently reliable or certain to allow
Forgive me for
individualization.
interrupting you, Mr. Glenn, but I take it that in our conclusion in Patterson, we said evidence of fingerprint individualization determined by application of the ACE-5 method to single latent fingerprint impressions meets the Lanigan-Daubert reliability standard. The general acceptance of this application of ACE-5 by the fingerprint examiner community leads us to this conclusion. I take it that your argument is, in light of the National Academy of Sciences study, we would not write that sentence again.
That's correct.
I thought so.
And would not apply the Frye standard, which is dependent upon general acceptance in the relevant scientific community.
I'm not saying I agree with you. I'm just saying that's the nub of your argument.
That's correct, because that kind of acceptance can't be the standard when you're challenging the very discipline of that community.
Okay. Is there any question in this case that the expert's testimony was a matter of opinion?
I think he stated it was a matter of opinion, and the science of fingerprint evidence is a matter of opinion. It's totally subjective, and they testified that it is subjective. It's based upon one individual's purported expertise and opinion. That's the nature of fingerprint identification.
And there was the jury weren't deceived into thinking that, no, it's not a matter of opinion, it's a matter of precise scientific calculation.
No, yes, they were. He stated it was an absolute match.
Well, as a matter of opinion.
No, he didn't. That part he didn't put in opinion. What I'm saying is the nature of fingerprint identification as such is a matter of opinion, as the report points out. But at trial, he testifies with absolute certainty that it is a match. It's an individualization. So yes, the jury is misled into believing that there is a degree of certainty in the match between the latent print and the ink print, so that they can rely upon that with certainty that this is his print.
In the judge's instruction on expert testimony didn't clear that up, saying, look, you don't have to believe this guy?
Well, it's a standard instruction on expert testimony, and frankly, Your Honor, I don't think such instructions do anything to remove the effect and the prejudicial effect of this. The same would be in DNA evidence at some time in the past. The judge there would always give the same instruction on expert evidence, but this court said, hey, you can't express it that way, you have to express it statistically.
And
that
if there were-
instruction doesn't cure the prejudice.
And if this were a battle of experts, would the jury have been misled?
If both of them stating with
Opposite
absolute certainty, I think so.
With opposite conclusions?
With opposite conclusions.
The jury would not have been misled.
They would have been.
Why?
Because they would have been misled into believing that what is going on for them is a search for certainty in this match when that certainty can't be established.
Well, it would be apparent that it couldn't be established if you had experts with opposing views.
But you have two experts saying something that's not scientifically valid, that you can establish with certainty a match.
Well, doesn't that then expose this science as sort of puffery?
It may and it may not, but generally it will not because, frankly, of the bias in favor of the Commonwealth's experts, as we know, is there. When you have that expert saying it's an absolute match, it comes in with the prestige and the integrity of the government behind it, that's going to carry a lot of weight. And frankly, it's not going to be outweighed in most cases by just another opinion saying, well, I'm certain that it's not. In fact, I don't believe a defense expert could, in a case where there are several matching factors, not enough for any certainty, but several matching factors, he could probably not say with absolute certainty it's not the print, and probably no expert would say that. And that's the problem.
Thank you, Mr. Blair.
Yes, thank you.
Mr. Townsend?
Thank you. May it please the Court, Thomas Townsend for the Commonwealth. Just to clarify, there were two fingerprint experts. Lieutenant O'Hara was the second expert, and he explicitly testified in terms of opinion. He was asked by the prosecutor, upon comparing the impression and the card, did you form an opinion, sir? This is page 187 of volume 6. He said, yes, I did. Yes, I did. Next question. Based on a reasonable degree of scientific forensic certainty as to those two prints, yes, I did. Can you tell us what that is? That the known print of Jesus Gambora matches the recovered latent print. The prior expert, Lieutenant Drock, whose testimony is at the same volume 6, pages 84 to 106, he never used the word match. He never used the word absolute certainty. He used the word individualization.
Mr. Townsend, go ahead, Justice.
If the question is put, based on a reasonable degree of scientific certainty, and is it Lieutenant?
Lieutenant. Yeah.
Lieutenant O'Hara says, yes, these are the same. That's the problem. I mean, that's the argument that the defendant is making, is that you can't base it on scientific certainty because there isn't a scientific certainty that would support that.
Well, I think that's incorrect. I think there is, based on the case law and by the forensic community itself, that there is a scientific
Taking
basis.
into account the NSA study?
Both of them took exception with the two leading groups, the Scientific Working Group, SWG, FAST, and the IAI. Both responded. They embraced some of the recommendations by the committee, but they took exception with their critique of the science.
But wouldn't that now go to I'm not talking about this case. I'm just trying to work this out. What you would now have, I take it, is another Daubert hearing when you would put before the judge the NSA study, which is pretty strong language, and then you would have experts come in from the other two interest groups, and they would, challenge certain of the findings, they would accept certain of the recommendations, and a judge would have to make that determination, right? Because there has been a change from a pretty serious body, independent body, that suggests that there may be a problem with this evidence in terms of how it has been used in the past. And the procedural question that I'm trying to get to is, assuming that we were to conclude that, is that appropriate in this case? Unlike, you heard my question to Mr. Graham, unlike new developments in the law, this is new developments in scientific evidence, and yet Patterson is pretty clear on that point, and so I don't know what would have happened if the judge had had the NSA study in this case.
Well, I would dispute that this report contains new evidence on the law. The report was very
Mr. Townsend,
clear.
it certainly, you may
Comes
dispute
to a
it.
different conclusion than, I mean, it does have the National Academies of Science taking a view that is contrary to the relevant the fingerprint community.
Well, the report made clear in its executive summary and its introduction in the testimony before Congress that it is not opining on the admissibility of any evidence.
No, of course it's not doing that.
No, it's
The
not.
issue has been raised before this court.
Now,
not
the issue
first.
has been raised, but you've got...
Since the NAS report, and the most prominent court to address it is the Florida Supreme Court as of date. And the court concluded that there's nothing new in the report. It's merely a summary of the existing arguments that were out there before. Many of the citations in the report are to literature over the years. It's a consolidation of what's viewed as...
Don't you think, though, that that the person hearing such a motion, having in front of him or her the NAS study, and yes, it's a compilation, but it's got the imprimatur, of the NAS. Don't you think that might make a difference when the judge is looking at all of this evidence again?
Well, under the standard as it now exists, the inquiry is whether there's looking at the relevant community, whether there's general acceptance of the theory and the process. And that has not changed. The report has not impugned that at all.
But that's not sort of looking at what else one might take into account other than or in addition to the relevant community.
I agree, but under Patterson, and the Patterson stopped after the first criteria was met, and that there was no further need to go through the further Dalbert factors because the relevant community, the theory that was the general consensus, and the process itself, the ACV method, which is used in every jurisdiction, has been found reliable. There is not a single published decision from any court in the country that says the ACV method is unreliable. The report references over and over and over a Maryland trial judge in an unpublished decision that found the ACV method to be unreliable. The Rose case, which I cite the federal equivalent in my brief, and the Rose case itself is cited in the defendant's appendix. Interestingly enough, in the Rose case, after the trial judge in Maryland suppressed the identification evidence, that was removed to the federal district court, and the federal district court judge, in the published opinion, found that the ACV method was reliable and repudiated or distinguished the NAS report. The NAS report was then extant. And also the judge noted that the Maryland Court of Appeals found that ACV method is a proper subject for judicial notice, and therefore further contradicting what the Maryland trial judge had done. That's all they could find. They also referenced a New Hampshire case, which is also cited in the defendant's appendix. That case actually dealt with a judge who excluded evidence because of the ACV method as applied. The prosecution took an appeal and won before the New Hampshire Supreme Court. So that doesn't add any substance to the NAS.
It seems to me that there's a
position.
confusion between looking to what courts have said as opposed to looking to what the scientists are saying.
Well, interestingly enough, the scientific working group in their response to this report said there were no forensic, or there was a lack of forensic examiners on the committee. They didn't dispute a lot of the recommendations. A lot of the recommendations
Well, most of the recommendations were it would be great to have more and better studies and more money and better labs and better training. And
a federal agency
how can you
to oversee
disagree with
everything.
that? How can you
The
disagree
only
with that?
recommendation particular to fingerprints was, interestingly enough, an expansion of the fingerprint database. They wanted to expand and enhance and make it interoperable. AFIS.
Yeah, because it's very reliable.
Right, and
It's
I
very
think
important.
implicit in that is that fingerprint individualization is a proper means of solving crimes, and they say as much in the report. So the only specific recommendation having to do with fingerprints is with respect to the database. Now, the committee made very clear that they are only going to do a general view of forensic science. They were given a huge mission by Congress to survey the field and give certain recommendations. The defendant has 8 pages in his appendix devoted to fingerprints. That's pretty much the crux of the report. The report itself is 300 pages, and the defendant has 8 pages in his in his appendix. So I don't think it alters the landscape as far as fingerprints go. More particular to this case, there are two overarching concerns that I would submit frustrate the defendant's attempts at a new trial based on this issue. Number one is the defendant here testified to having touched the door pull. And the defendant relies on the Harrison case to make that argument, saying that that should not be factored in the calculus because he was coerced based on the admission of this testimony. Well, Harrison dealt with a very specific instance where illegally obtained confessions were admitted at the defendant's trial. He felt compelled to testify to explain his confession. That case was reversed, remanded for a new trial, and the prosecutor used that trial testimony from the defendant in order to convict him. The Supreme Court said that was impermissible because the defendant, number one, it could be readily deduced that he was coerced based on the admission of that confession. And number two, based on notions of judicial integrity, we couldn't allow that kind of evidence to come in. And number three, in order to deter police misconduct that was present in that case, it would be improper to allow that confession to come in.
Don't you think there is something about, to the point, I mean, it comes up in Melendez-Diaz, that if the ruling has been, as it was here and had to be under Patterson, that the fingerprint evidence was coming in and that somebody was going to testify to an opinion that there was a match of what was on the door and the defendant, that it is a curative. I mean, in other words, he's got to say something about it. So can you really hold that against him?
Well, number one, I don't think it can be readily deduced that this was the evidence that coerced his testimony. There's evidence that's admitted all the time.
Not coerced his testimony on everything, but just on this point.
No, well, I think looking at Harrison, you have to meet the three criteria. Was there police misconduct in this case? No, there's no police misconduct. This was generally accepted and is generally accepted evidence. Number two, is the judicial integrity compromised by admission of the evidence, and it is not in this case. And number three, it can't be deduced. There is no mention at trial that my client's going to testify, and the only reason he's testifying is because of the admission of this fingerprint evidence. That is not, there was no objection as there was, I believe there was in Harrison. And also, the Supreme Court in Daubert said that there are three things to deal with admissible but shaky evidence, if this is even deemed shaky. Number one is vigorous cross-examination. Number two, presentation of contrary evidence. Number three, careful instructions on the burden of proof. That all occurred here. The defense counsel cross-examined the first expert for 50 pages, and it was vigorous cross-examination. And the expert admitted that errors had been made. So that was before the jury. Errors had been made in fingerprint identification, and the jury was free to consider that. So I think there's no reason to remand or reverse this case based on the state of this case. And also, the defendant doesn't make a claim that this report is newly discovered evidence. The Florida Supreme Court has already rejected the notion that it is. But there was no motion for a new trial in this case. And there's no, he's trying to say that there was an abuse of discretion by the trial judge 4 years ago, and the reason there was an abuse of discretion was that this report released last year.
No, I think that the position isn't it that the trial judge hands were tied because of Patterson. So I don't know that.
In fact, the hearing or the conclusion, excuse me, was delayed while before to wait for this court's decision in Patterson.
That's right. We held the prosecution in advance because this issue is presently before this court.
Yeah.
Once this court resolved the issue, holding that it is admissible evidence.
So here's my
forward.
question to you, Mr. Townsend. If we assume, as you say very simply and straightforwardly in your brief, that nothing in the NAS report impugns the Patterson conclusions, if we agree with you on that, no problem, right? If we don't agree with you on that, then what?
If you don't agree with me on that, then I think you have to step back and look at the position of this case. The defendant testified. He admitted it was his fingerprints. I don't, for the reasons I outlined.
And then you say we don't get bound by his Harrison argument.
Right,
doesn't hold
and this
water.
court has distinguished Harrison
Okay.
similarly. So I don't think that's a consideration in this case. Again, I relying on the Rose decision in the Federal District Court and the Florida Supreme Court decision.
No,
I don't think there's any valid contention that there's anything new. These are the arguments that have been bandied back and forth for years.
I'm not, I was going specifically to the Patterson one, because then if it's, the trial judge didn't, the motion judge didn't have any alternative but to apply Patterson.
Correct. Yes.
So, as I say, if we agree with you, no problem. If we don't agree with you, then what? And I think what you're saying is, because he testified, and then you don't get to Harrison, so we affirm the conviction, correct?
Correct. I do believe that perhaps a judge taken as a performing his or her gatekeeper function could take a look at the report, and, as Judge Gertner did last month, and say this may be enough to warrant a Daubert hearing. But that's prospective in a case that we don't have.
But we had a Daubert hearing here, right?
There was, in Patterson, there was a 5-day.
No, in this case.
Not in this case.
Because
They held it, yeah.
We held it
because of Patterson.
because of Patterson.
Yeah.
And he wasn't challenging any of the evidence or the process with respect to his case. He was just challenging the science in general.
Yeah.
Right.
It was a complete general. And once we got the Patterson decision, we went forward with prosecution.
And they would be absent now, I mean, notwithstanding Patterson, now I assume even in the trial court, a defense attorney could say there's some new scientific evidence. There might be a little, dispute about whether it's new or not new, but I don't think it would be entirely inappropriate for a judge to take that into account. I mean,
On a case that's still in its infant
Yeah,
stages.
yeah.
Yeah.
And in fact, the judge could conclude that, in fact, there could be another Daubert hearing. The individuals could testify from this sort of fairly distinct community, and the judge could conclude that it remains generally accepted in spite of the NAS sort of compilation of reports.
Right. And as this court
The
recently...
question is, it's an abuse of discretion standard as to whether the judge...
It's still abuse of discretion applies here. As this court said earlier this year in Shanley, there can be developments in evolution of a science, and no science is grandfathered in. So there could be a new Daubert hearing in light of this, and this court on a full record would be able to address the admissibility of the science at that point. This is trying to look back and say would have, could have, should have, because for a report that came last year, we did everything right in this case. We held up the prosecution. We waited for this court's decision in Patterson, and we went forward. The defendant didn't dispute it. They were his prints. With respect to that one particular, I do want to respond to one thing that occurs in both the defendant's briefs. He says that the defense counsel in his opening statement said that there would be no evidence placing the defendant at the scene, and somehow that the defense counsel was surprised by the admission of this fingerprint testimony. Number one, this was all determined pre-trial in a motion to eliminate that the evidence would come in. The prosecutor referenced the fingerprint evidence in his opening. If you look at the defense counsel's statements in context, he immediately right before that said that he wanted to explain why there are so many charges, and he wanted to emphasize there's not different instances. Everything occurred at the same time in the same building. And then he said there were a lot of people in the building. And then he went on to say there's no evidence that will place the defendant there or at the scene. I think a fair reading of that opening is that he was referring to in the building. And then he went on to say that there was no positive identification by any of the victims.
Because his fingerprints were found on the door handle. And
Everyone knew that.
His story was, I was about to open the door and two guys burst out and said, we just killed somebody, and they took off.
Right. So
together.
technically, the defense counsel's statement was true. There was no evidence that placed him in the building. And I think that was his point. It would be ludicrous, right after the prosecutor says there's fingerprint evidence on the door handle, for a defense counsel to get up and say there will be no evidence that he was there. He was talking about in the building. I think that's clear in the context of the opening argument. And then everything has to, I submit, has to be viewed in light of the defendant's testimony. Even if there were error somehow in this case, that it's rendered harmless by his testimony, placing himself and explaining away the fingerprint. I do want to make one more point with respect to the shoe print. The defendant also makes a Harrison-type argument that the shoe print, the defendant was coerced to testify to explain away the shoe print. The defendant in his testimony, this is quite clear in light of his testimony and the closing arguments by both counsel, he never explained away the footprint. The footprint was located behind the efficiency apartments. The defendant never said he went there. He specifically said he went straight toward the getaway car or the car with his Confederates. So he never laid claim to saying that that was his shoe print. And defense counsel got up and said in his closing argument, if the defendant wanted to explain away all the evidence, including the shoe print, he could have said, yes, it was my shoe and I went around the efficiency, but he did not because he was telling the truth. So it was clear that he was not coerced to explain away the shoe print because the shoe print still remained out there and the defendant still denied making that shoe print even after he testified. So the Harrison argument falls flat in that respect with respect to the shoe print.
I take it that if I understand correctly, with respect to the shoe print, the objection or the argument is that not that there's some scientific reason that Lieutenant O'Hara couldn't talk about the similarities, but that his shoes were bigger. I think bigger. So it couldn't be his. Is that?
Right. He says he wore size 10. In his case,
there's no scientific attack on the expert opinion about the similarities. Right.
Defense counsel agreed that Lieutenant O'Hara was an expert in the shoe print field, that the attack was a relevancy, and I think there was a foundational attack. The defendant, in his own testimony, testified that he wore size 10. The jury was not required to believe that. They seized the sneakers from a bedroom that contained his paperwork and pictures depicting him. It was from an address that he provided to the police. The jury can infer that it was his room and, by extension, his sneakers. Just because the defendant gets up and says, those weren't my sneakers, that goes to the weight of the evidence, not the admissibility. Unless there's further inquiry from the court, I'll rest my brief.
Thank you, Mr.
Thank you.
Townsend.